Okay.
Well, I wanted to object to the cameras in the courtroom. I filed an objection last night.
The cameras are duly here. They are allowed to be here. I have an open court. It's even in my department guidelines somewhere that I believe in fair and open access to courts. All right, I'm going to call page 4. This is case number A22851472C, T. Phillips Esquire versus Shannon Wilson Esquire. Could I have appearances of counsel, please? Although I understand that the plaintiff is proceeding pro per. Mr. Phillips, are you on?
Yes, good morning, Judge.
Okay, good morning. So we have Mr. Phillips on pro per, and then could I have counsel for Ms. Wilson, please?
Good morning, Your Honor. It's Dan Waite from Lewis Roca representing the defendant, Ms. Shannon R. Wilson. I understand there is another attorney locally, Shannon Wilson, so I emphasize the R. Wilson.
Good morning, Mr. Waite. Okay, Mr. Waite, this is your motion. I have read it. I mean, I will tell the parties, I think your motion is in good order. If your client has not been served, she has not been served.
May I interrupt, Your Honor?
Well, actually, may the court finish speaking? Okay.
Well, I wanted to object to the cameras in the courtroom. I filed an objection last night.
Well, I'm sorry, I'm over. The cameras, they have an absolute right to be here. I granted the media request, so the objection is overruled.
You misunderstand my objection, Your Honor. I'd like to be heard.
If you want to put it on the record, go ahead.
Well, I guess I'd like to put it on the record. I filed a motion last night. Have you read it, Your Honor?
Do you think I read stuff in the past 24 hours if it's not brought to my attention? I was not aware that you filed your motion. So why don't you go ahead and argue your motion right now?
Well, I filed it last night because they filed the media order yesterday. So I filed it as timely as I possibly could. But here's my problem.
Well, actually, Mr. Phillips, let me interrupt you. They actually made a prior media request, which had been granted. It's in the record.
Right. Yeah, and I have not had a chance to oppose it. Here's my problem. What happened is when our Nevada judges sent a proposed order to the court, they did not notify the parties, and neither did the clerk of the court. If Your Honor actually reads Supreme Court Rule Section 230, you will learn that once a request is made, the request has to be served on the parties. So the clerk of the court failed to serve the request upon the parties. And what happened is when Your Honor signed the order, nobody knew about it. And the question is, do we have a right to notice an opportunity to respond?
Okay, Mr. Phillips, go ahead.
I got cut off there or something. The only thing I was trying to say is that when they send the media order, it's an unauthorized ex parte communication. If you read Nevada Code of Judicial Conduct, when the judge receives an unauthorized ex parte communication, which it was, the court has an obligation to tell the parties about it ahead of time. Your Honor had signed the order before the parties knew anything about it. And the 14th Amendment requires notice and opportunity to be heard. The Nevada Code of Judicial Conduct requires notice and opportunity to be heard. I did not have prior notice, neither did the defendant. Nobody's had an opportunity to respond to it. And that's the problem. So what I would recommend is that we take a time out and then reschedule this hearing and brief the matter.
So I'm denying your motion. There was a media request and order filed into this case on August 31st, 2022. Okay, you had plenty of notice. You are on the e-service for this case. And in any event, in my view, I can allow cameras in the courtroom as a matter of course. And so I'm denying the objection or motion. The cameras are duly here. They are allowed to be here. I have an open court. It's even in my department guidelines somewhere that I believe in fair and open access to courts. And so I'm denying the motion. We are going to proceed on with the motion that Ms. Wilson made. Please don't interrupt me. Please don't interrupt me. I did not interrupt you. Please do not interrupt me. Okay, we are going to proceed with the motion today. I have denied your motion. All right, Mr. Waite.
Thank you, Your Honor. Defendant Shannon R. Wilson. Yes, this is our motion, and Your Honor, if it were not for an event that occurred yesterday that I'm going to mention here in a moment, I would be inclined quite candidly to just rest on the briefs. I think it's that clear of an issue. But the event that occurred yesterday is that Mr. Phillips served Ms. Wilson. Interestingly, did he contact me as counsel of record who has offered 9 times to accept service for Ms. Phillips? No. Did he contact Ms. Wilson to ask her if she would accept service as she has previously offered to do? No. Did he send a process server to her house to serve her? No, that would not be dramatic enough. Instead, what he did is sent a process server to the law offices of Hutchison and Steffen to serve her. Now, did his service yesterday change anything? No.
That's my next question.
For several reasons, Your Honor, it does not matter and it doesn't change anything. It would be the functional equivalent as if service occurred yesterday and I filed my motion today. The motion today would still be that it was defective and late service. And Your Honor, that leads to the second point that I'd like to make, and that is what is the analysis that applies in this situation? Service now has been accomplished. And for that, Your Honor, there is the Nevada Supreme Court has set up a regimen where it depends on whether the motion to enlarge time, we're way beyond the 120 days. We are 47 days, as of yesterday, we are 47 days beyond the 120 days. And so the Supreme Court sets up a regimen that says, is the motion to enlarge time made before the expiration of the 120 days or after the 120 days?
Do I have a motion to enlarge time in front of me?
Therein, Your Honor, is the first problem, is that it is fatally defective because you do not have a motion to enlarge in front of you. In fact, as the Nevada Supreme Court, by the way, I didn't even see, well, neither here nor there. The Nevada Supreme Court in the case of Saavedra-Sandoval versus Walmart Stores, 126 Nevada 592 at 597, 245 Pacific 3rd, 1198 at 1201 at 2010, published opinion said, quote, the Nevada rule does not give the district court discretion to enlarge the time for service in the absence of a showing of good cause. And here is the important point, continuing with the quote, the district court is limited to enlarging the time for service only upon a motion to enlarge the 120-day service period, end quote. No motion, full stop. The dismissal is required. It's not discretionary. But for sake of argument, let's assume that there was or is a motion to extend the time for service after the 120 days. As I said, we're now 47, I believe, days after that point. In that case, the motion would be after the 120 days. And under that scenario, it's a two-step process that the Supreme Court has indicated must be followed. The first step is a threshold issue, and that is, did Mr. Phillips show good cause for not filing his motion before the expiration of the 120-day period? There's absolutely no good reason Mr. Phillips could not have filed a motion to enlarge before the 120-day period expired. With all due respects, stubbornness, obstinance, recalcitrance is not good cause. We've laid that out in our brief. He knew there was an issue about his defective service through the e-system for months, almost from day one. He's a lawyer. He could have researched the defective service issues. If Your Honor is looking up, it's not in the rule 4E2, I believe is where. Instead, Mr. Phillips made a calculated choice to stand his ground on his e-service. And in fact, he said he welcomed the opportunity to litigate the issue. Well, he got his wish. But making a calculated decision not to file a motion to enlarge the time is not good cause. So without good cause for his delay in filing a motion, again, we're at full stop. The motion must be denied. As the court said in that same Saavedra Sandoval case, quote, failure to demonstrate such good cause ends the district court's inquiry. Step one is threshold, no showing of good cause, that's over. But Your Honor, I'm going to go to the next step, because if you rule in my favor, I'm going to ask that I be able to that I create the order that is consistent with what is both in the briefs and what I'm arguing today. And so I'd like to get that in the record. Step two of that analysis, if he can get beyond step one, and he can, is Mr. Phillips must then show good cause for enlarging the time. And the Supreme Court, in a separate case, Scrimer versus 8th Judicial District Court, 116 Nevada 507 at 516, 998 Pacific 2nd, 1190 at 1196, a 2000 case, set forth a 10-factor analysis for the court to consider whether to enlarge time if they can get beyond the first threshold. And I apologize that it's 10 factors. I'm not going to spend much time at all on each.
I'm familiar with the factors.
Okay. Do you want me to explain why they're not satisfied here?
Well, no, look, I'm very much about letting people make their record, which is why I let Mr. Phillips make his record on an objection he filed at 11:30. I just looked, 11:35 p.m. last night, and I had no idea had been filed. And if you want to make your record, go ahead. But in my view, Mr. Waite, we don't even get to this point because I don't have a motion in front of me, and I don't typically, unless a motion has been made, I don't have anything to rule on.
The only reason that I suggest belaboring the record with the 10 points is Mr. Phillips has demonstrated himself to be very litigious. I suspect he's going to appeal whatever result. And if there's an order that says his motion is denied for this reason, but even if we get beyond that reason, he loses for this reason, and even if we get beyond that reason, he loses for this reason, I think you provide the Supreme Court with guidance and say, well, it doesn't matter because the district court would have threefold or fourfold denied the motion. And that's the only reason I defer to you.
Sure. No, I understand. Let me hear from Mr. Phillips. Mr. Phillips, I've read these papers. It seems pretty clear to me, and it seems, you admit you didn't serve timely. I know you make an argument. I read all your papers. I know you made an argument that Ms. Wilson, of course, had noticed. And I don't think the defendant is disputing that she knew about the lawsuit. But what I need to hear from you is how do you get around all the case law and all the rules that say you've got to personally serve?
Well, the thing is, Your Honor, mischaracterized. It's not a question of, I've never said she has notice. Mr. Waite has brought up several cases, and I'm familiar with them. Just because a defendant knows about a case does not mean service. Well, I'm not saying she knows about it. I'm saying that I've used Tyler Host with this woman for 4 years in the family law case, in the appeal case, in the Supreme Court case, in Washington, D.C., Supreme Court case. I've used it every time, and she's never objected to it. The point is, I believe it's wasteful under the circumstances to burn up a dinosaur worth of fossil fuel and cut down trees to deliver paper just so Shannon Wilson can scan them and put them on her desktop. She has a file stamped, date stamped, a copy of the complaint that is unalterable, it's unquestionable, and she has had actual possession of that document, and I can prove she's had actual possession of the document the whole time. It's not like she merely knows about it. She is in actual possession via a service that she uses all the time. So the point is she knows about it. It's not a question just knowing about it. She actually has it. Now, even if the court were to dismiss the case for service of process, I could turn around and filed the same thing again. It really makes sense, I believe, to get to the material points of this case and to litigate it rather than to just dismiss it perfunctorily. Because if the court does dismiss it, I will likely appeal and file the same lawsuit again anyway. So in the interest of avoiding wastefulness, I think it makes sense to have them pick a date and actually file a responsive pleading. That's my position with respect to service. And I still want to be heard on the cameras because the court didn't give me an opportunity to make a complete record on cameras in the courtroom. I heard Your Honor say that at your page you have information about your policies with respect to cameras in the courtroom. Well, I haven't seen your page, but I'm curious, what are the policies about notice and opportunity to be heard? Because I'm not disputing Your Honor's central thesis on the idea of cameras. Yes, cameras in the courtroom it's a fundamental thing, and I understand that. However, if you read Section 230, it gives the parties an opportunity to respond, and I have not had that opportunity prior to today, prior to the day that Your Honor signed the order. It's not a question of whether there should be cameras in the courtroom. It's whether or not the judge is going to be signing orders that materially affect the party's case, and they have no idea. The order that Your Honor signed was basically in secret, and I can see that Your Honor is making an argument that the earlier order is somehow an all-purpose order that lasts forever. And that's not my understanding. That it's not like they get to sign a media order, then they're good for all time. They have to request it for every occasion, is my understanding. And the reason I did it at 11:35, whatever it was last night, is because I was served with the order at whatever time it was yesterday. So I did it as quick as possible. But again, getting back to the idea of service of process, Shannon Wilson has actually had the lawsuit since day one. As soon as I sent it to her, I also sent a corresponding email. 21 days to respond. Please help yourself to 30 days. But this is how stubborn Shannon Wilson has always been. I explained to Mr. Waite that a defendant can waive personal jurisdiction requirements, and he doesn't recognize that as a possibility. He thinks it has to be personal service or something in the code. He doesn't recognize the possibility of simply waiving service, sending a simple one-time email, thank you, Mr. Phillips, I'll accept your 30 days extension to file the pleading, and we'll do it that way. But they didn't. They are just every bit as stubborn as they possibly can be about this. And again, to dismiss the case for service of process seems kind of ridiculous because it's just going to cost both parties $270 to refile. And I will say, it seems to me that they've already acquiesced to jurisdiction. The fact that Mr. Waite is here today, he didn't make a special appearance for the sole purpose of contesting jurisdiction. That's what I would have done. But it seems he's here to make a general appearance, and he's arguing on the merits. So I would say that there already is personal service by virtue of the fact that they paid the fee and that he showed up here today to argue. So I would ask the court to schedule this matter for a hearing, first of all, on the camera issue, and secondarily, there's another issue with respect to our Nevada judges, is that they are on the service of process list. And from what I understand, you can't have third-party interlopers just adding themselves to the service of process list. I don't see any paperwork where Alexander Falcone asked for permission to be added to the e-service list in this case, and he's doing it all over town. When I understand the purpose of cameras in the courtroom, it's like saying a person can walk into a courtroom and see, view the ongoings. When I was coming up as a lawyer, I remember many years ago sitting and watching cases and watching other lawyers. Well, at no point did I ever think to stop the proceedings and put myself on the service of process list in connection with the case. The point is that right now, our Nevada judges is on the service of process list in this case. How did he get there? Who let him add himself to the list. Again, my understanding is the clerk of the court is supposed to maintain a list of those parties and their attorneys who are enabled to receive service of process on Tyler Host. So how did Alexander Falcone add his name, and why is the court going to let him do this without permission from anybody? So I would ask this court, there's three things I'm hoping to do here, is to brief this issue on cameras in the courtroom, because there are factors. No matter how much Your Honor is passionate about cameras in the courtroom, there may be instances where those cameras cause prejudice. And I believe if I have a chance to execute an affidavit and explain all the facts, Your Honor will see that and Your Honor will agree the cameras are here inappropriate because of who Alexander Falcone is and the people that he represents. So I want to be able to brief this issue of service of process. I would ask the court to remove Falcone from the service list along with our Nevada judges, and I would ask the court to give them 21 days or 30 days to file an answer or other responsive pleading. And I think that's it.
All right.
Response, Your Honor?
Yes, last word, Mr. Waite. You don't just respond on the papers. I don't think you need to respond on the cameras motion.
Okay. Well, in no particular order, Court of Nevada has long ago gotten rid of the special general appearance distinction. Possession, Mr. Phillips was arguing that Ms. Wilson has had possession of the complaint. She has. We do not deny that. We've never denied that. But under that analysis, to use an absurd example to make the point, Your Honor, if Mr. Phillips had a carrier pigeon deliver a copy of the summons and complaint, according to his analysis, he would have actual possession, and that would be good service. Of course, it is not. There is a fundamental reason, Your Honor, why it matters, why you should dismiss this action now, even if Mr. Phillips does, as he threatens to do, just turn around and refile. And that fundamental reason, Your Honor, is when he filed this original complaint, it was 8 days before this Nevada Supreme Court resolved the issue that is key to this matter. He might have an argument, although I think his complaint is defective substantively for many reasons. If he now, after that opinion has been issued, refiles, I want him subject to Rule 11. I want, because I will probably respond to that filing with a Rule 11 motion. I will ask the court to find him to be a vexatious litigant, and he needs to be put to the test that he's going to go forward and refile, knowing now what he knows that he didn't necessarily know when he filed this action. He says he wants to get to the material points of the lawsuit. Your Honor, that is, with all due respect, a very rich comment, especially considering that I offered numerous times to accept service of process for the very purpose of getting beyond the service issue and getting to the merits. He said, well, we should just offer to waive service of process. Again, Mr. Phillips is forgetting that the very first of those 10 offers to accept service was Ms. Phillips' offer to accept service, and her offer was to send me the form to waive service under 4.1 or 4.2, and I will sign it. And Ms. Wilson even directed Mr. Phillips where to find the waiver form. But he was stubborn. He wants to litigate this issue. He got it, and for all of these reasons, the action should be dismissed.
Very good. I'm going to rule on both matters that are before me. The first matter that is before me today is Defendant Shannon R. Wilson's motion to dismiss the complaint pursuant to NRCP 4E2. I am granting that motion for many of the reasons that are set forth in the defendant's opening and reply briefs. To address a few of the arguments that have been made here today, NRCP 4 in the case law, which has interpreted and applied NRCP 4, is very clear. When you originate a proceeding, you have to have originating service, which means personal service. by way of someone personally serving the defendant or defendants in the case. While I understand the arguments of efficiency and expediency that have been made about, in this day and age, should we be moving forward with personal service, that issue is not before the court. That is not an issue that this court decides. This court is constrained by precedent and by the case law that the Nevada Supreme Court and the appellate courts have decided. And that law is very clear. Personal service is required, and it is undisputed here that personal service was not made within 120 days of the filing of the complaint. Accordingly, the court grants the motion. The court will now address the objection that was filed at 11:35 p.m. As an initial matter, what the court will say is when a litigant late files, and I don't mean late files as in necessarily untimely, but late files as in 11:35 p.m. with a 9 a.m. hearing, the court would encourage the litigants to notify chambers that such a document is pending. However, regardless of the late night filing of the objection, the court has heard from Mr. Phillips on his objection. The court would direct people to the media request and order that was signed by the prior assigned judge to this matter. In that order, it is ordered that the media request is granted. Moreover, in addressing some of Mr. Phillips' comments, the order expressly states the requested media access remains in effect for each and every hearing in the above entitled case, at the discretion of the court and unless otherwise notified. This order is made in accordance with Supreme Court Rules 229 through 246, inclusive at the discretion of the judge, and is subject to reconsideration upon motion of any party to the action. Well, while I'm still not certain about the well-foundedness about Mr. Phillips' arguments that his 14th Amendment rights have somehow been violated by the secret media grant, which the court does not find that it was a secret media grant because it was filed into the record, the court points out this August 31st media grant, which was made over 1 month ago, and to which Mr. Phillips had plenty of time to object and respond had he chosen to do so. Accordingly, Mr. Phillips' objection is overruled. This case is dismissed. Thank you very much, everyone. I'm moving on to the next matter.
Your Honor, may I prepare a detailed order?
Given that I have a pro per litigant, despite the fact that he is counsel, I think in at least California, my typical practice, Mr. Waite, is that I prepare and enter the order so that there is no need for back and forth.
Perfect for me.
All right. Thank you very much.
Thank you.
Alex here, just very quickly, I'm just going to explain that the media submission, the media request submission in this case is the same as every other case in the state. There's nothing different or exceptional or secret about it. The process is actually discussed by the Supreme Court in a case called Solid versus 8th Judicial District Court, and it is completely routine for us to submit the request to the department. The judge signs the request, files it into the record, and then if attorneys have any objections, they file their objections after the fact. I haven't heard of any situations where they actually stall the proceedings to deal with the media request. In fact, in the case that I mentioned, Solid v. 8th Judicial District Court, the recordings had already come and gone by the time the Supreme Court took a look at it, and they just invoked something called the mootness exception to discuss it. This is something that I've had to go through before. It's not anything special for Mr. Phillips to have to go through this process. Just like all the other lawyers who try to get rid of our cameras, he has to follow the same process and procedure that all the other lawyers do.